To our surprise, the prosecution rose to ask the court to be allowed to withdraw the application. We couldn't oppose the withdrawal because our position from the beginning is that the application had no merit and it was going against the right to fair trial. You cannot be subjected to trial with a blindfold where you do not know who is your accuser, where the evidence is coming from. So, whereas we welcome the withdrawal, we also note that the court's time has been wasted, and we said it to the court, because 2 days of cross-examination, the prosecution must have known that their case was very weak, and that is why they have withdrawn to avoid dismissal. We asked the court to allow withdrawal with prejudice, meaning they cannot bring such an application again. But the court has given them a free hand. We also asked for costs. The court also has not allowed the costs. And the court now has ordered them to give full disclosure by tomorrow and ordered us to come back to court on the 1st, which is Monday. We are not happy with that because we will not have had time to sit down with our clients to know what is contained in the full disclosure, to get instructions, and for us also to be able to advise our clients. When we expressed displeasure in court, especially of the judge refusing to give us a date for our bail application, yet he is giving prosecution dates on every application they bring, including the one that he has just finalized. He has requested us to go and canvass that in chambers with the prosecution. So from here we will go to chambers. But we and our clients feel that the judge has not treated our applications fairly. He's giving the prosecution priority. The scales of justice must always balance between the defense and the prosecution. And a court of law should never be seen to be leaning on one side. We have at least pointed that out to the court.
No question?
My Lord, this was an application for witness protection. Where prosecution sought to protect the 6 witnesses. And my Lord, 6 witnesses. And my Lord, the defense made an application to have Mr. Chomuhendo Joseph, the deponent for the applicant's stroke prosecution, to be cross-examined. My Lord, this cross-examination started from 23rd of April 2026, 23rd of April 2026. It crossed to 6th of May 2026. And now today, the 28th of May, 2026. My Lord, as prosecution stroke applicants, we have realized that the continuation of these proceedings under this miscellaneous application number 101 of 2026, the witness protection, are delaying the commencement of the hearing of the substantive case, the actual hearing of the substantive case. And as such, the prosecution stroke the applicant is applying to have this application withdrawn as we consider other appropriate protection measures for the 6 witnesses which we deem will be effective, appropriate, suitable, and above all practical, without affecting the expeditious trial of the main case. Because any further delay, my Lord, will be contrary to Article 126 2b. Will be delaying the main trial. Is therefore our prayer, my Lord, that although there is no specific law or section to have this application withdrawn, we believe that this court has inherent powers under Section 37 of the Judicature Act, Cap 16, to grant any remedies to any party before it, and the application for withdrawal of this application not being exceptional. It is our belief, my Lord, that the withdrawal of this application would serve the wider interest of expeditious justice. Therefore, our prayer that, my Lord, you grant this application and have this application withdrawn to enable prosecution to make full disclosure of the said 6 witnesses and we have the substantive case, my Lord, fixed for hearing. Without much delay, we so pray, my Lord.
we are urging that the court allows the withdrawal with prejudice. Mr. Birubumbukas Kampot, I've just asked the court, say we have no objection to the withdrawal, but they feel with prejudice that you cannot bring the same application again, especially so because the prosecution has waited for the court to utilize 2 days of cross-examination of the witness, yet nothing new has happened. They could have evaluated the options open long before they brought the application. We therefore believe that the application has been made at this stage because the prosecution has realized through the cross-examination that their application was ill-advised and has no grounds to stand on. We're therefore asking, my Lord, that the court takes the unusual step, utilizing its inherent powers to allow the withdrawal on a prejudice basis, but to also take the unusual step to award the defense costs of the 2 days this application was prosecuted, which cost should include my airfare from Kenya and back for 2 days. Because it is unnecessary that for any of us to bring an application where you have other alternatives. We also do seek the courts to require the prosecution to obey its earlier order on full disclosure and to give a timeline so that we may return to court for scheduling and for the court to be satisfied that the full disclosure has been made and therefore the case is now ready to proceed. Before I proceed to my colleagues who may want to make additional comments, I want to draw the court's attention that we do have a bail application. I don't know whether the court wants me to do this after that, this application. We do have a bail application, criminal application number 0213 of 2026, which has been allocated to you, my Lord, and we will be seeking for dates at the end of this, noting that our clients have been in custody, A1 and the A2 have been in custody for a whopping 558 days as of today. I don't know whether Apollo has something. Then that's all. For A3, that's all for A1 and 2. For A3,
Right court to find that there was no prejudice in the withdrawal of this application.
By what happened, you are withdrawing will not be again using that evidence.
yes.
Yes, my Lord.
This means he cannot come back for the same.
My Lord, I was going to it. It is also, my Lord, it would be very unfair for court to say never bring an application of that sort again. We did this application because it was taking a lot of time. Precisely. So whether it comes up or not is an issue of a reassessment. And then, my Lord, prosecution cannot be condemned to costs in this matter because it had no control over the period when cross-examination took place. And in any case, my Lord, the record has it, my Lord, I made it categorically clear on the 23rd day of April 2026, before Chomuhendo Joseph could be cross-examined, that the matter, that application be expeditiously had on that same date. And I'd even prayed to ensure that each advocate is given specific time within which to cross-examine. And my Lord, it was the discretion of this court that counsel for the respondents or the accused persons take their time in cross-examination. And that explains why you have taken all these days, my Lord. So we pray that this court finds that application, my Lord, redundant, given the circumstances. It is our prayer, again, that, my Lord, this application, as court, since they have not objected to it, it is withdrawn unconditionally. There shouldn't be any conditions attached to it, because our focus as a prosecution is to have an expeditious trial of the main case, which we think should be the focus of defense. We so pray.
Misango ya treason ne misprision of treason. Nako lwalero tuze twetegese kuddamu okubuuza eyawa ekirayiro mu application ya state ey'okukweka ebikwata ku bajulizi omukaaga be balina okukozesa mu musango guno. Nti bwe tutuuse mu kooti, oludda olwabi ne lutegeeza kooti nti bo tebakyayina kye baagaza application eno era basaba eggibweyo oba egobebwe olw'okuba tutta obudde bungi era nga balaba nti abavunaanyibwa bamaze ebbanga ddene mu kkomera, nti basaba kooti egende mu maaso n'okuwa olunaku olw'okutandika okuwulira guno omusango. Tubadde tetukiinaako obuzibu okuggyayo application eyo kuba obwedda tubadde tugiwakanya, naye ne tugamba nti omulamuzi abagambe engeri gye baggyeyo application eno abawe order, abalagire nti tebajja kuddamu kwonoona budde bwa kooti kuleeta application mu ngeri eri bweti y'okukweka abajulizi. Omulamuzi n'akikkiriza era application n'agigoba. Ne tugenda mu maaso n'okutegeka omusango gwennyini bwe tubadde tulina okutegeeza kooti gutuuse ku stage ki, nti omulamuzi n'alagira prosecution etuwe obujulizi bw'abo abajulizi omukaaga obubadde busigaddeyo n'ebirala byonna ebibadde bisigaddeyo mu disclosure. N'abagamba balina bituwa ennaku z'omwezi 29 Ogwokutaano olunaku olw'enkya nga tezinnawera ssaawa 11 tusobole okwetegeka tubiyitemu ne bakirayanti baffe era tusobole okudda mu kooti nga tuli beetegefu okutandika okuwuliriza guno omusango. Naye misango ekikola bwe kiti tuba tulina okunoonya ba assessors oba abantu aba bulijjo abalina okuyambako kooti nabo bagiwe endowooza yaabwe. Yes, endowooza yaabwe terina kyamakulu kyegatta ku nsalawo y'omulamuzi, nti naye eteeka bwe lityo bwe liragira. Naye nga tetunaba kubakkaanyaako ba assessors abo, tuba tulina okubakolako okunoonyereza ffe tulabe beetengeredde balina obumanyirivu basoma basobola okwetegereza olulimi lwa kooti twe tuba tusanzeemu akanyomero konna ke tulina okuchallenginga tugenda kujja tukategeeze kooti nga tetunagenda mu maaso nakubalayiza nti omusango gwongezebwayo mpaka nga 1 omwezi ogw'omukaaga mande we tugenda okudda mu kooti eno ku nsonga ezo. Bwe bakusomera omusango mu kooti yonna oyina options zibeera 3. Esooka osobola okukkiriza omusango plea of guilty, eyokubiri osobola okugaana plea of not guilty, eyokusatu osobola okusirika n'ogaana okuddamu omusango gwonna gwe bakusomedde. Nti naye bw'oba ogaanye okuddamu ku musango gwe bakusomedde kooti neera egenda mu maaso newandiika nti gogaanye omusango gwe bakusomedde era nekuteekako plea of not guilty. Kati awo we tugendera mu maaso n'okukola trial yonna nga bw'erina okubeera.